on the Accelerated Planning System Government Consultation. Hopefully you've all received found this link, so that's a good sign. And this also outlines the agenda. But just to clarify, we'll start with colleagues from DLUC giving a presentation on the 4 strands of the consultation. The 4 strands are the 10-week accelerated planning process, the proposed changes to the performance regime and extension of time, simplifying the process of written reps, appeals, and varying and overlapping planning permissions. This presentation will be delivered by Stephen G and also Catherine Holton from DLUC. Following this, there will be a questions and answers session. And for this, we'll be using Slido. So Slido is really easy to use if you haven't used it already, and you would have received the link on Slido in your email. Also in the chat, there's also a link. And also when we give the presentation on each of the slides, there'll be a Slido link. So if you haven't downloaded the Slido link, then there's plenty of opportunities still to do that. Please can you post questions on the Slido, and could you do that if you can during the presentation? My colleagues Liz and Shelley from PAS and also myself will be managing the questions that you're submitting, and what we will be doing is grouping those questions under the 4 categories of the consultation. Obviously there's a lot of people on this call, so that's why I'm asking you to try and put your questions in whilst the presentation is going ahead, so we can do a bit of work in the background, lumping them all together. Also, what would be really helpful is you'll see there's a thumbs up or like box actually on Slido. If you see a question that you think is a really good question, and please like it. Or if it's a question very similar to the question that you were just about to ask, also like it. And that way we can prioritise the questions that we ask. So it goes up the league table, as it were. So please do use that facility. What we will do is we will direct the questions to Stephen and Catherine, or to ourselves, depending on what the question is. If we can't get through all the questions, we will endeavour to get the answers posted after the webinar. You will notice that we have actually turned off the Teams chat facility, and this is simply because there are so many attendees today, and we want to ensure that we can properly order the questions that are asked. So it just makes it easier for us to manage it if you use Slido, and that's why we're pushing the use of Slido. Please, however, note that DLUC can only take into considerations comments that you formally make through the formal government consultation process. So please do that in addition to asking your questions today, and any comments you make today cannot be considered by the government as part of the formal response to the consultation. So it's really important that you...
You're muted, Pete.
Oops, it's gone off. Is that better? Back again. I don't know what happened there. Sorry about that, everybody. Sorry, where were we? Yes, just say the consultation deadline is the 1st of May. So please don't miss that deadline. Finally, just to say that we are recording this session, and we will be posting the recording on our website, and we'll be sending you a link to that. So if there's anybody you know who couldn't attend today and wants to see this session and hear what's being said, then please do share that link when we send it out to you. Okay, I think that's everything. So what I will do now is I will hand over to I think it's Stephen, is it, who's starting? Who'll be giving the Stephen, and then Catherine will be giving a presentation from DLAC.
Thanks, Pete. And whilst Catherine gets up the slides, I'll just introduce myself. Thank you, everyone, first of all, for coming today. It's great to see so many people on the call. For those that don't know me, my name is Stephen G, and I work in the Department for Levelling Up in the Development Management Division. And my team is responsible for local authority performance, resourcing, and fees. Peter's already given a good introduction to what the consultation is. Catherine, if you don't mind going to the overview already, that the next slide, that repeats what Peter's already introduced in terms of the contents of the consultation. I won't repeat any of that, but just to kind of explain the structure of the presentation, I will talk about the first three sections. So that's the section relating to the accelerated planning service, the section on performance measures and extension of time agreements, and the section on the changes to the appeals service for written representations. And then Catherine will talk about the fourth section, which is the one around section 73B applications and the treatment of overlapping planning permissions. And yet, just to repeat, the consultation runs until the 1st of May. I really would like to stress this is very much a kind of consultation at the early stages of policy development. We really are keen to get the comments, the responses from as many people as possible to help inform the development of these particular proposals. And we're particularly interested in the views of the potential impacts of any of these proposals on local authorities, including the way in which you might deal with planning applications. Next slide, please, Catherine. So, first of all, the first section of the consultation relates to the accelerated planning service. So this was introduced through an announcement by the Chancellor as part of the autumn statement towards the end of last year. It is proposed that all local authorities would offer a new application route through the accelerated planning service, and that would cover commercial applications with an accelerated determination period of 10 weeks and a refund if this timescale is not met. The consultation focuses on two main options that we're exploring. The first one is a discretionary option where applicants can choose to use the accelerated planning service where they meet the particular qualifying criteria or prescribed information requirements. Or if not, if they want to, they can continue to use the standard application routes for major developments. The other option we're testing views on is a mandatory option where the accelerated planning service would be the only available application route for applications within a given development category. But the principle of an accelerated planning service would apply. The consultation sets out the proposed scope of the service. So this is proposed to apply to major commercial applications which create 1,000 square metres or more of commercial floor space. But we are also interested through the consultation to hear the views on whether or not that scope could be expanded in future to include other applications such as infrastructure or residential development. It's proposed that there would be some exemptions that would apply to any application that went through an accelerated planning service route. So those exemptions would include applications that have been screened as EIA development, applications that are subject to the Habitats Regulations Assessment, applications that are within the curtilage of a listed building or involve other designated heritage assets or situated within World Heritage Sites, for example. Also, it wouldn't apply to applications for retrospective development or applications for minerals and waste. I think it's important to be clear that the expectation is that even though this would be an accelerated planning route, there would be no loss of scrutiny expected as part as through these applications, or any sort of special consideration of these applications. They would follow the same statutory requirements for consultation as you would for any major application. But what is important in order to ensure that applications can be determined within an accelerated timescale is that we have made clear that those applications should be of good quality, and that involves encouraging applicants to engage with local authorities at the pre-application stage, and also for applicants to notify key statutory consultees prior to submitting any planning application. In terms of fees, to cover the additional costs associated with delivering an accelerated planning service, we're seeking views on what the appropriate fee level would be for that. The expectation would be that the fee should cover all the costs that the local authority would incur in delivering an accelerated service, representative as a fee uplift. And we're seeking views from people as to what an appropriate percentage fee uplift should be. And then finally, one of the key kind of points of the accelerated planning service is the principle of a fee refund. So we are seeking views on whether that should be a full refund, whether that should be a partial refund in stages. But the principle is that an element of a refund, either whole or partial, would be provided, would be given back to the applicant after the 10-week timescale has been reached if the application has not been determined, even if an extension of time has been agreed. Next slide, please, Catherine. So the second part of the consultation relates to planning performance and the use of extensions of time agreements. The first thing to mention is the separate publication of a planning performance dashboard. A link to this is provided within the consultation document, but this is a new draft table which we are seeking feedback on prior to its first formal publication in June as part of the usual quarterly statistical release that this department publishes. The performance dashboard effectively looks to add an element of greater transparency around the use of extensions of times, the amount of applications that are subject to extensions of times, and those that are determined within statutory periods, including figures on applications on hand as well, I think. So there's an added level of detail here on local authority performance. And if you haven't done so already, I would really encourage you to take a look at that dashboard and give us any sort of feedback you might have on its value to you, and whether the statistics are things that you think are helpful for the department to publish. In terms of the actual proposal in the consultation, the first relates to the changes to the planning performance regime. So firstly is the proposal to include a metric for speed of decision making against statutory time periods only, i.e. without extensions of times, as is currently the main measure that we use to measure performance. We're seeking views on whether we should continue to use both measures if we introduce this new measure, or whether the new measure would effectively become the only measure against which we monitor performance. We're also seeking views on the proposed thresholds for how we would measure performance for statutory time periods only. So within the consultation document, we've suggested that the measure should be set at 50% of the major applications. So that's 50% of applications within the statutory time period, and 60% of non-major applications. We're also seeking views on whether the assessment period for speed of decision making would be better set across a 12-month period rather than the current 24-month period against which we monitor performance. And finally, on the performance measures, we're also seeking views on appropriate transitional arrangements for any sort of new measure. We recognise that it's not reasonable for us to introduce a new measure and then kind of make performance decisions immediately. There needs to be a sufficient time period in place in order for local authorities to adjust to any new measure that may be introduced. So that's the proposals in relation to the kind of performance measures. And then the second half, if you like, of the performance and extension of time agreement section relates to proposals that we are seeking views on in relation to removing the ability for extension of time agreements to be used for householder applications, and also removing the ability for repeat agreements, so extensions of times after extensions of times, to be used on the same applications for other types of applications. So i.e. you would only be able to seek one extensions of time for that application and one only. So we're really interested to get views on that and what that might mean for you and your decision in terms of local authority decision making. Next slide, please, Catherine. And then finally for me is the section relating to a proposed simplified process for planning written representations appeals. So people may be already familiar with the kind of current simplified or expedited process that exists for householder appeal service and commercial appeal service. And the proposal is that we look to expand that simplified appeals process to cover a much broader range of written representation appeals. Effectively, a simplified process would remove opportunities for main parties and other interested parties to provide additional information at the appeal stage. We think this would help to reduce pressure on local planning authorities. It would encourage applicants to submit information or amended proposals directly to a local authority and engage with a local authority on those issues instead of seeking to consider that at an appeal stage. And also it would help support the planning inspectorate's timely processing of written representation appeals. Appeals determined through the simplified route would be based on the appellant's brief appeal statement, plus the original planning application documentation and any comments made at the application stage, including those of interested parties. So there would be no additional information required to be submitted other than that was included as part of the application. It's also important to say that the simplified process would only apply where a decision has been taken. So that means it would not apply to appeals against non-determination and also appeals against enforcement notices in order to allow further submissions to be made in regard to those matters. And the planning inspectorate would still retain the ability to decide the appropriate appeal procedure. So in cases where PINs decide that the simplified process is not appropriate, the appeal would instead just follow the kind of existing kind of current non-simplified written representations route. And indeed, if an application was deemed of such complexity or scale that it actually wasn't appropriate at all for written representations, then it exists. The kind of PINs are able to choose whether or not that should be dealt with by a different appeal procedure, such as hearings. So there are the first three sections, which I've very quickly gone through. And now I will hand over to Catherine, who's going to talk in more detail on the fourth section, which is section 73B. Over to you, Catherine.
Thanks, Stephen. Hi all, I'm Catherine Holton. I work alongside Stephen in the Development Management division here at DLUC. So yes, we want to just cover off what's in the consultation on section 73Bs around varying planning permissions. So just wanted to kind of spend a little bit of time just talking about the kind of background as to where this has come from. So the diagram in this slide kind of shows you a bit of a kind of almost timeline of what's happened, particularly in terms of issues raised in case law on section 73s. So there's been some limitations highlighted on section 73 in case law, particularly the Finney case, which confirmed that section 73 cannot be used to amend the descriptor of the planning permission. And from this, we've seen kind of case law establishing that permission granted under section 73s cannot introduce a condition which creates a conflict or is inconsistent with the description of a development. So as a result, we've seen a sort of standard practice come in where you kind of looking to minimise the level of detail provided in the description of a development, and thereby reducing any potential for future scheme amendments to conflict with the description. So that's why in the LURA we brought in section 110 to kind of introduce this new route, which would enable more material variations to planning permissions, what we're calling section 73Bs for development, and that would be for kind of not substantially different to that granted by existing planning permissions. And the idea of section 73B is intended to deal with the issues raised in case law by allowing both the description of the development and the conditions to be varied in a single process. So some of the key areas that we are consulting on in terms of the actual implementation of this section 73B firstly around kind of when you would use section 73Bs versus the standard section 73 process. And the idea is that the section 73B route would replace the use of section 73 to deal with proposals for general material variations, whereas the use of section 73 would return to kind of focusing on the variation of a specific condition. And kind of looking at using section 73Bs in terms of kind of the benefit around that would be allowing a return to more kind of clear and specific descriptions to help improve transparency of development for local communities in particular, and we'll be looking to put some guidance out on that as well. The next proposal is around kind of what we mean by substantially different. So there is a restriction on the use of section 73B in that the amended development cannot be substantially different from the existing development. So we wouldn't be looking to give prescriptive guidance on what is meant by substantially different. That's because it will kind of depend on the scale of changes required in the context of existing permissions. But we'd see kind of factors such as location and the scope of existing permissions and the proposed changes would be relevant in these cases. We've also got proposals in the consultation on fees. So we'd be seeking to align the fee for section 73B applications with the fee for section 73 applications. And as part of that, we are proposing to change what is a current flat fee for a Section 73 application being £293 into 3 separate fee bands. So we'd have a householder fee band of £86, a non-major fee band of which would remain at the £293 rate, and then a major development fee. And that's where we're seeking views in particular in terms of what that fee would be. It potentially be a higher fee but less than the fee of the original application. And finally, the proposals kind of set out again what would happen in terms of SIL, and the idea is that SIL would apply to Section 73B in the same way that it applies to Section 73 permissions. Then just a few points in terms of the key legal features of Section 73B, and then also the procedural arrangements. These are again also set out in the consultation document, so hopefully you can have a read of those. But the idea is that a Section 73B would identify the existing permission and proposed conditions for new permission, and an application for planning permission to a local planning authority. The determination for a Section 73B application would be subject to Section 70 and other decision-making duties. But the APA cannot grant permission for a Section 73B application if the effect of the Section 73 permission would be substantially different from the existing permission. And when determining the application, they would limit their consideration to the variation between the application and the existing permission. And then, like a Section 73 permission, Section 73B permission is a separate permission to the existing permission, and so the granting of a Section 73B would not affect the validity of the existing permission. And finally, just to kind of flag that it would also apply to permission in principle. And in terms of procedural arrangements, they are in most cases kind of generally the same as other applications for planning permissions, but certain requirements wouldn't be required. For example, design and access statements. The consultation with StatCons would follow the same approach to Section 73 applications, and EIA and HRA requirements would apply as for Section 73 permissions, and a similar approach for B&G. And finally, just to cover off what we've got in the consultation on overlapping planning permissions. So this is kind of to respond to some more recent case law that we've seen coming forward, particularly in the Hillside and Dennis cases, where we've seen kind of overlapping permissions, where there's a bit of a question about the ability to use drop-in permissions, where a subsequent permission is granted for an alternative development on a section of a larger development previously granted permission and is still being implemented. So the idea is the new Section 73B route could be a way to provide kind of a new way of dealing with such changes to a specific phase of a large-scale development granted through outline planning permissions. So the proposals in the consultation seeking views about the extent the Section 73B route could be used to grant permission for changes for outline planning permission, and what are the constraints. So we'd see Section 73B changes would often continue to fit within the existing master plan, which underpins the outline permission, and do not necessarily fundamentally change the permission. However, we do recognise that there would be circumstances where that route might not be appropriate, And so the change could be considered substantially different. So as I mentioned earlier, that will be a key part of the Section 73B proposals. So we're also keen to explore whether there's other alternative options that might facilitate the operation of overlapping permissions. So that could be one proposal we've given as an idea is for a general development order to be used, but very keen to get views as part of the consultation as to any other kind of routes that could be used as well. So that's the end of our presentation. I will stop sharing.
Okay, thank you very much, Catherine and Stephen, for that. We've been busily trying to order your questions, and thank you very much, everybody, for the number of questions that have been asked, which is absolutely brilliant. To just say that the majority of the questions are on the first two, which is the 10-week consent and the performance, then followed by the Section 73B, and there's less questions on the appeals. So what we'll try and do is divide. We've got just under an hour. We'll try and sort of divide those up. And just to answer one question which somebody raised right at the beginning, what happens to the ones that don't get thumbs up? Do we still answer the questions? Well, yes, we will try and answer every question that's raised. It's just, I think it's only fair the number of thumbs ups are the ones that we ask the DLUC colleagues to answer in this session. So we'll try and get through as many as we possibly can. I'm going to do the first one. So this is about the 10-week consent, and if you just bear me a second, I will go to the one which is most popular at the moment, and that is regarding the statutory consultees. So sometimes there's a delay in the waiting for statutory consultees. How will proposals take this into account, bearing in mind it's 10 weeks? Can I pass it over to Stephen?
Yeah, I'm not surprised. That's probably one of the more popular questions we would get asked. And yes, I mean, I think that we recognise that a 10-week determination period is a significant acceleration than 13 weeks even, but even, you know, what tends to be a more delayed kind of timescale than that even. What I would say is within the consultation document, we do mention that DLUC are currently undertaking a kind of independent review of the statutory role of statutory consultees, and recommendations from that review will kind of come out, and that's particularly looking at how statutory consultees can improve their service and timeliness of service. Government has oversight over statutory consultees, and so we will continue to kind of look at performance and monitor performance in relation to accelerated planning applications, and indeed all applications. There is a particular question there in the consultation that does ask people to for comment how statutory consultees could best support an accelerated planning service. And as I said in my presentation, one of the key things that we would like to encourage as part of an accelerated planning service is the pre-app engagement, and particularly notification of statutory consultees. In the consultation, we haven't gone as far as suggesting that would be a mandatory requirement, but it's something that we would strongly be encouraging local authorities and applicants to kind of follow through with before submitting an application under an accelerated planning service route.
Okay, thank you very much, Stephen. That's very helpful. Right, we've got another question again, which is being very popular, and again, not surprising. The push for quicker decisions is likely to lead to quicker refusals. Has there been any consideration on the impact of potential demands on PINs?
I mean, again, I mean, part of the consultation is to try and seek as many views as possible on the practical implications of matters relating to extension of time agreements. I would stress that what we're proposing is not to remove extensions of time agreements for anything other than householder applications and instances of repeat extensions of time. So extensions of time is something that still would be possible for the vast for the applications, major applications, albeit only one extension of time. I mean, yes, a consequence of that could be a greater rate of refusals. The applications would potentially become more transactional. That's particularly why we're keen on seeking views on that. And also, yes, if there was a greater rate of refusal, potentially there would be knock-on consequences for appeals. But again, that's something that we would have to take into consideration following closure of the consultation and the views that we received back. Also bearing in mind the proposals that I've mentioned for broadening the simplified appeals process for written representations.
Okay, so thank you very much for that. It's sort of on the same lines. I think there'll be are there any penalties proposed for developers who submit half-baked proposals but still want to work with planning authorities? I suppose if this issue is, you know, I suppose the consequences of speed against applicants who are putting in, as I say, as the question was, half-baked proposals. How are we going to? Are there any proposals on that? Yeah.
Yeah, I mean, I think I mean, if we're particularly talking about the accelerated planning service route first, I mean, like I say, the emphasis is on pre-application engagement, so that applications that are submitted are of a quality that would enable an accelerated delivery timetable to be achieved. We do in the consultation talk about a kind of prescribed criteria or information requirements that would be required to be submitted with an application in order for that application to be considered under an accelerated planning timetable. And so there is scope, one would assume, for a local authority, if they didn't receive that information, to not consider to validate that application under that route. That is something that we would need to work through following the consultation and consideration through potential regulations as to what would be the relevant criteria or information requirements for those applications. More generally, I mean, I think you know, again, it's for the local authority's discretion to ensure that their applications are suitable for validation purposes based on their local list of requirements. And again, as we always have done, really, pre-application engagement is encouraged for those applications where it would be beneficial to have those discussions beforehand and hopefully then ensure that the application that is submitted isn't half-baked and isn't able to be considered within the required timescale.
Yeah, thanks, Stephen. Yes, I think that's an important point about the local validation list. Obviously, it's to a certain extent within council's own gifts on the local validation requirements. The next one, it's I think the second part is a bit sort of tongue in cheek, but do we have any stats on the number of majors that are currently determined in 10 weeks? And the questioner is saying, how feasible is this option? And then I think the point then about how often does PINS determine an appeal in time is maybe a bit rhetorical. But I suppose the main point there is about, do we actually have any national statistics? Do you know about 10-week achieving majors in 10 weeks? I mean, we will know when they're in time, won't we? But I don't know if you've any.
Yeah, not in terms of 10 weeks. I mean, as per the returns that we receive from local authorities, we ask you to determine, we ask you to kind of state how many applications are determined within the relevant statutory period. So that obviously 8 weeks or 13 or 16 weeks, or an agreed extended period. So in terms of the data that we receive back, we don't have data kind of then that we could identify any applications that are determined within 10 weeks, only those that are determined within the statutory periods.
Right, okay, thank you. The next question is about applicants who drag their feet in responding in order to exceed the 10 weeks and get a refund. But, well, presumably the response to that is a refusal, is it? So I suppose the point here is that will applicants consequences that applicants will sort of drag their feet just because they want to get a refund, and they don't expect the council to actually determine it in 10 weeks, and they know they get the refund as a consequence. Any thoughts on that?
Yeah, it's an interesting one. I definitely welcome views on this. I mean, this is where we really are quite interested in what people consider might be the kind of practical consequences, unintended consequences of this. I mean, the starting principle, as per the Chancellor's statement, to be honest, was very much this service is something that is of importance for kind of commercial operators, for businesses. The expectation is that such businesses would not be wanting to drag their feet. The whole point of an accelerated planning service is because applicants want to get a decision as soon as possible, that there would therefore be less inclination to drag their feet. But of course, that is something that we would need to consider further. So we'd definitely kind of welcome if people have particular views on that. Would be interested to kind of hear that and consider that further.
Okay, thank you. I mean, the next question is about the consultees again. So I don't know if there's anything else you want to add about this, but it's really about has there been any research with the consultees? Presumably, we're talking particularly with statutory consultees on the ability of them being able to respond within the 21-day consultation period.
Like I say, I mean, it's not something I personally have been involved in, but the work that the department have been doing at pace at the end of last year in terms of the independent review of statutory consultees has looked at this and other issues relating to statutory consultee performance, and you know, kind of measures and recommendations coming out of that will be considered and if appropriate taken forward by the department. I'm not directly involved in that review, so I don't know any of the detail of the recommendations, unfortunately.
Right, okay, yeah, thanks. And the next question is a very simple one. Why 10 weeks? How was that derived?
Well, the idea was that it had to be less than 13 weeks, and it was considered what was the most appropriate period to enable, like I say, appropriate consideration of an application, appropriate consultation and notification processes to have been undertaken. Again, the consultation is seeking views on whether 10 weeks is the appropriate one, whether it should be less or whether it should be a different one. That was the basis behind the decision. There is already a 10-week statutory one for public service infrastructure applications. I don't think we get a lot of them, but there is an application route already that allows for 10 weeks in those circumstances. But yeah, again, very interested to receive views on whether they feel 10 weeks is an appropriate time period.
Okay, yeah. Thanks so much for that. So sorry, the ones going up to the top of the list keep on changing. So
we're rattling through these, Pete.
yeah, we're rattling through them, aren't we? So the revised plan. So would revised plans be accepted on an application if they used the accelerated service, as this could cause delay. So I suppose it's issue about accepting amendments. Presumably the answer is up to, is it discretion of the planning authority there?
Yeah, so again, it very much is quite open, and we're open to views on this. But what we say in the consultation is that even with the accelerated planning service, there is scope to agree an extension of time if there are issues that are, for the benefit of both parties, beneficial to resolve. And if that means extending the period beyond 10 weeks, then it makes sense that that ability is there. What we are saying, though, is that the principle of a refund would still be maintained, even if an extension of time was agreed. So and obviously extension of times then impact on performance figures and things like that. But if there was scope for amendments to be submitted with an application, or to the benefit of both parties, then that ability would be there. Again, going back to what I said at the beginning, the idea with the accelerated planning service is that a lot of these issues are discussed and resolved prior to the submission of the application. So the need for any sort of revised plans is hopefully minimal, but of course through consultation that might not always be the case. So the principle of an extension of time is still there if an applicant and a local authority both agree that that is the best. I hope that answers that question.
Yeah, okay, thanks. So we just lost you just at the end there. That's I think we got all I did anyway, but I think you're fine. Yeah, we got the. I think we'll just need one more question on this one, then we need to go on to the next section because there's loads of questions coming in. This is about the financial penalties. I'm not surprised with this one coming up. Could statutory consultees share the penalty with the planning authority, with the refund? So i.e. if a statutory consultee doesn't meet their requirements, shouldn't they be penalised as well as the planning authority? If you want to make any comment about that.
Well, I'm not going to make any comment other than the fee that we're proposing for an accelerated planning service is a fee for the local authority. It's not for others. And we're again, like I say, we're seeking views on where that fee should be set. And aside from what I've already mentioned in terms of the review that's been undertaken on statutory consultees and taking that forward and more closely monitoring performance, that's all I would be able to offer, I think, in response to that. But again, grateful for any views people want to make on that through the consultation.
Thank you very much. Right, okay, we better move on to the performance because there's a lot of questions on that. And just to clarify, the questions we haven't got through, we will endeavour to answer them after this webinar. So moving on, so Stephen, we're firing questions at you at the moment. Right. But this is on the performance, and the biggest one by far actually is regards extensions of time. Extensions of times are agreed by both parties, so why are they a problem? Isn't a slower positive decision better than a fast refusal or a poor quality approval?
Well, that is the fundamental question, isn't it, to these proposals? And again, is something that we're definitely interested to get views on. As I said, we're not saying that extensions of times are not possible in circumstances other than householder, and in those instances, I think there is a belief that the issues associated with those applications are less complex, and it should be possible to determine those applications within the 8-week statutory determination period. If it's not, then yes, the service does become more transactional, I suppose, and I think that's an interesting challenge for us as well as local authorities about how, if this measure was to come into place, how that would alter potentially the the behaviour of applicants and the behaviour of local authorities in determining those applications. Speed has really been a concern. Speed decision making has been a concern, and it has been a particular concern in relation to the smaller applications, which obviously are the kind of greater volume of most, maybe not all, but most local authorities. And you know, particularly the work that we've been doing recently and the funding that we have been providing to some successful local authorities to address backlog. In a lot of instances, we've found that this is, you know, backlog as a result of those kind of smaller applications, and getting on top of that backlog and is important. But we're not saying that we want to get to a situation where applications are just refused. But it is recognised that we do need to focus more strongly on the speed of decision making in local authorities.
Okay, thank you very much, Steve. So another very popular one about planning committee. So what if an application needs to go to planning committee and it takes it over time? Presumably the answer to that is that's factored into the timescale, is it? I don't know if you want to say anything.
Well, I mean, if an application has to go to planning committee, I mean, like I say, extensions of time is still possible. We would monitor it. What we're proposing is to monitor the proportion of applications that are determined within the statutory period more closely. So if an application has to go to committee, then that would be factored in. If you have an extension of time to facilitate that, then great. But if you don't, then obviously that's one that you would have to take a hit on in terms of your overall performance figures. My expectation is that householder applications would not need to go to planning committees. But again, we're interested in views on whether or not I'm wrong in that assumption. So those applications that would go to committee, my expectation would be that extensions of times, if deemed appropriate, could still be achieved. Hope that answers that question.
Okay, yeah, and I think that's a challenge to planning authorities, who I know a lot of planning authorities have a lot of householders going to committee, so I suppose it's a challenge for the scheme of delegation and working with members to say, well, actually, should some of these applications be going to planning committee? But yeah, I know it's a big issue for officers in planning authorities trying to persuade members that they don't need to see every householder application. So next question is about resourcing and with the rise of extensions of time. Again, this is very much to the heart of a lot. I know a lot of planning authorities will be feeling this. Is the poor resourcing, i.e. lack of staff, and also the poor quality of applications, rather than masking poor performance. So has any consideration been given to the fact that planning authorities are under-resourced, applicants submit poor applications, and that's why you need extensions of time?
Yeah, there's a lot to unpack there, isn't there?
Yeah.
So of course, I completely understand that resourcing is a constant issue for local authorities. We have increased planning fees recently to help support that. I know that is not enough, but it is there to provide increased resourcing for local authorities. In addition to that, we are supporting. We've got the Capacity and Capability Fund, which is providing additional resourcing for local authorities as well. And so there is measures that we have put in place and continue to put in place to provide as much support as we can to local authorities to support their resourcing. The issue on the quality of applications, again, perhaps goes back to the point I raised about where, you know, we really do feel that there is value in pre-application services, which I would stress is also something that local authorities have the flexibility to charge set their own charges for pre-application and bespoke services. Appreciate the staff to be able to do that, which is something again that we're through our capacity and capability team, we're looking at ways in which we can help introduce new planners into the public sector. But that is the key way in which I think you can try, as well as local lists, as you mentioned earlier, Pete, is there to kind of help local authorities to ensure they get the best quality applications before they are at submission, having had that kind of pre-application engagement. But yeah, I appreciate those are challenges to local authorities in determining applications in an effective way, in an efficient way.
Yeah, and as you rightly say, Stephen, this is a big issue, which I know it's been tackled from a number of sources, the government, and obviously from PAS, we're helping the government with that area. So with regards to, I suppose this is again, I hear this quite a lot about are we not in danger, or is the government not in danger of creating a perverse incentive for local planning authorities to prematurely refuse applications rather than seek to positively resolve conflict? So the default position is driven by the timescales rather than actually creating sort of actually delivering, I suppose.
Yeah, I mean that is something that I've heard a lot in terms of the, what is it a case of what is more important? Is it speed? Is it quality? I mean, I would be saying that if possible to in general achieve both, if we focus on the ways to most efficiently determine planning applications. Like I say, again, the extensions of times are still there as a mechanism available for the larger scale applications, where I feel there is scope for the mutual benefit of all parties to if necessary, in order for a scheme to address any sort of unexpected issues that you might kind of associate with a more complex and large scale application. Less so as for the kind of smaller applications, which are considered to be achievable within those statutory periods more easily. Of course, there are mechanisms, I haven't even mentioned this, but there are other mechanisms which we're not proposing to change at all, but planning performance agreements for the really kind of larger or more complex schemes is still something that local authorities can do if they feel that those schemes are more appropriate to be determined within a kind of bespoke programme with an applicant, and local authorities can introduce their own charging regime for PPAs.
Right, okay, yeah, thank you. The next question is about, I think it's we look at the evidence, and I suppose the evidence the government has that LPAs use extensions of time are masking poor performance, because I think that does come up in the consultation information about, is this a sweeping statement, or does the government have evidence that its extensions of time are actually masking poor performance?
We believe in a lot of instances it does. We're interested to receive the views of local authorities if they don't consider that is the case. Again, I think there is this distinction between extensions of times that are used on the smaller and less complex applications compared to the major or complex applications where an extension of time may be more legitimate than whether the smaller or householder matters, whether they really can't be achieved within 8 weeks or not. But again, the purpose of this consultation is to ask questions about this and seek the views of both everybody, but including local authorities, on whether or not they agree that extensions of times are as much of a concern as we believe they are.
Okay, so thank you. I'll just have one more question on this, and we need to go on to the next section. And this is an interesting point about how will the drive for better quality development and less appeals marry with removal of extensions of time? Surely the two are opposing views. Yes, I noticed that in the consultation it talks about, you know, the appeals, you know, negotiate solutions, and yet there's a drive for speed. So they would appear to be slightly in conflict with one another. I don't know if you want to address that.
I mean, I think my view would be that they're not kind of mutually exclusive, if you like. It is possible to achieve both. I don't really think I should. I think I'd just be repeating what I've said already in a way, Peter, on that question. Yeah. But again, I mean, if people have particular views on the, you know, on this kind of you know, the practical kind of consequences of any of these measures, whether it's for them, whether it's for PINs, statutory consultees, or any kind of key kind of part of the planning application process, then we'd be really keen to hear those kind of views, because that's what's going to help us kind of think about the policies and proposals as we take them forward.
Yeah, it's a very good point. You know, it's time for people, you know, put that in the consultation response. You're getting a flavour of what people are going to be saying. Absolutely. Right, I'm just going to hand over to my colleague Liz, who's going to be covering the next two sections.
Hi everyone. Right. Well, I thought, Stephen, let's rest your larynx for a few minutes and let Catherine come to the fore. So let's focus on questions about Section 73B proposals. And we've got a couple of questions that are really standing out from the others in terms of popularity. The first one is about substantial difference and what that means. And the question is posed this way. It says, are we going to wait for the courts to rule on what is substantially different then? So how is that going to be defined? And is that the intention of DLUC, really waiting for a kind of court to decide?
Thanks, Liz. So I think this relates to what I said earlier around not planning to publish guidance specifically on defining what is substantially different. The reason we think it's best not to put kind of explicit guidance on this is because there is a risk that takes away from kind of the local authority's ability to make that local judgment and that local call on kind of individual cases. And what I think would happen with substantially different is you're going to be looking at factors of individual cases, including things like location, where it becomes quite difficult to kind of start setting national guidance on that without kind of starting to take away that local judgment element. But completely take the point. It is tricky to get that balance right, because we don't want to kind of be creating a whole nother layer of issues that we've kind of seen where this has come from, being a lot of kind of debates in the courts and things. So one of the areas we would like to do a bit more work on, would be keen to get views from local authorities in particular, is what would be useful in terms of getting that balance. And in particular, is there anything we could do in terms of guidance on maybe looking at some common approaches that we could use across local authorities, where you're kind of starting to use similar approaches for different things that way. So anything in terms of views on that would be really useful in the consultation response. Would really appreciate views on that.
Yeah, that's really helpful. So everyone, you know, that would be a really good point. That's a really good point Catherine's given to you for responses. So, you know, what kind of level of guidance would be helpful there? Okay, the second question we've got, a lot of thumbs up on this one, and it's about fees for Section 73 and Section 73B. applications, I suppose, that come forward. Concerns are raised that Section 73 fees do not even cover the cost of a notice in the newspaper, let alone an application that would be at EIA level. So I suppose that is a point being raised, but are you able to respond to that, Catherine?
Yes, yeah, to an extent. Yeah, appreciate these tend to be complex cases, and that doesn't come at kind of no cost, obviously, in dealing with them. So that's partly why, first of all, we're kind of looking at how we would set a fee that's consistent across both Section 73s and 73Bs. What we don't want to do is kind of have a different fee for Section 73Bs coming in that kind of then creates, I don't know, some sort of loophole where it's either better to do one or the other. So we want to kind of set a standard fee across both. And then we're also kind of, as part of that, looking at this kind of staggered fee. And so the idea of that was kind of lowering the fee around householder, keeping the fee the same around kind of non-major, and then increasing the fee for majors, particularly majors, because they tend to be the more kind of time-consuming, complex cases. But again, very keen to get views on that in the consultation. So, you know, not only just if that's kind of works as a general approach, but also, are they the right fees? If they're not, why? And that evidence is helpful for us to kind of make sure we're doing that in an evidence way.
So for local planning authorities to give an indicator of costs in their response and kind of evidence that would be helpful.
Yes,
I suspect.
Yeah.
But
yeah.
Okay.
Particularly on the kind of different scale points, because obviously that will be a new approach anyway. For Section 73. So anything in terms of how that might be working for them now would be really helpful.
Brilliant, thank you. Okay, so the next question is more. It is the third most popular question, and it's kind of framed in this way. So where a Section 73B, where in a Section 73B there is a limitation on the quantum of development, i.e. where a development applies a development with a certain fee and the amended would be higher. I think the question is asking, does the actual level of development determine the substantial change, I suppose, and is that a measure of what represents substantial change? Are you able to answer?
I'm not sure I can answer it fully, but I think it's something, again, it would be useful to kind of know more about that and what local authorities are coming across in terms of how it would apply in terms of what we're trying to do with Section 73B. I think it's an interesting kind of take on it in terms of, I guess, the quantum of development. And I guess difficult, to think about it without a kind of more specific example. But I think in terms of kind of around the point around development with a certain fee.
I think what I think the question is asking that. I think the key question is, if the amendment through Section 73B implies an increased fee is allowed, then it shouldn't therefore be allowed through Section 73B. I think that is the question. So what we could do is have a think about that, because these are quite technical questions, some of the Section 73 questions. Okay, so we will follow up with a closer look at that. Looking at the next one. The more complex a Section 73B application is, the less likely that the flat fee rate will cover the cost of processing it. So that is more a statement than a question, and I think we've probably covered that to some extent. So please make comments on that, as Catherine has suggested, and provide evidence of costs there. Okay, the next question. The costs outlined do not cover the internal costs of Section 73 at £294. These usually require reconsultation, re-advertising, and everything done again. So I think you're getting the gist of it. Similar points being made and similar evidence being made. Okay, so moving on to the next question. Section 73B, currently a combination of non-material amendments, change of description, and Section 73, change of condition, achieves this, but needs varied Section 106. Will Section 73B carry across a Section 106 agreement? So quite a technical question there. And what would be your interpretation of that?
I think it's one we would need to look into in more detail. It's certainly the sort of thing we're looking at in terms of how the implementation would work. I think in principle, the short answer would be yes. But I think it's something we need to look at in terms of kind of the implementation side of it. We're kind of probably a stage back from that at the moment. So I think what would be good to use is potentially some more detailed kind of focused discussions on some of these topic areas as to how it would be implemented in that way, because we're kind of, I guess, at the step of trying to think about what we need to put in regulations, and kind of coming out of what's in our levelling up bill, and was brought in the Act. We're kind of looking at the implementation side as the next step of regulations and guidance. So that feels like an area we'll need to explore as part of the kind of guidance element in particular. But maybe we could explore that in a bit more of a focus session. But yeah, it's a helpful point that we need to
So I think that's a really useful point there. One last one on this section, and then we'll move to appeals. Should the information requirements for Section 73B rest with the local planning authorities and their validation checklists, and be dependent on the specifics of the proposal? So I'm presuming this is quite a technical question as well, about the level of information required around Section 73Bs.
Yeah, so I think we're quite open to kind of knowing what is useful for local authorities with this. I think the key elements we've set out in terms of kind of information procedural requirements are trying to keep it in line with what we've already got in terms of what happens with Section 73s. Obviously, if there's reflections on how that's working and then how that could work with Section 73B alongside that, and better things we could look at, then that's helpful to know, and would be useful to definitely feedback that in the consultation. I think we've got a question on, well, it's on procedural arrangements, but would fit probably within that. So yeah, helpful to have views on that.
That's really helpful. I mean, these are really technical questions, and I think that everyone in this virtual room, in the webinar, is really interested in this section and in getting it right, because I suppose it's a recognition that it is helpful legislation, but it's about getting it right. So all of the information you could submit and your responses will be really helpful with that. So thank you for that, Catherine. So Stephen, we're going to move back to you now with the appeals questions, and this is the area where there are the fewest questions, and I suspect it's because we're all quite familiar with this simplified approach to appeals. So the first questions is about accepting new information. Will PIN stop accepting new information? So the Planning Inspectorate, we will have to refuse more. PINs accept new information and we will lose more appeals. So it's a kind of combination of a question and a statement. What's your response?
It is, and what I would say is, I mean, I don't know if Graham's still on the call, but if he is, put forward the PIN's perspective on some of this, then he's very welcome to join in. Yeah, I mean, I think a lot of this relates to kind of you know, how PINs are looking at their kind of service, and this process it will help. Well, like I said in the presentation, it will help both local authorities, I believe, in terms of reducing the amount of information that will be required to be submitted to PINs, and that in turn will then help PINs in dealing with those appeals in a more efficient way.
Okay.
Yeah.
I mean that's. I mean, I think the consultation is quite clear. That's the intention that sits behind, and I guess it's a question around PINs, you know, joining up with the purpose of potential changes. And a further question following up, Graham. Are you? I thought Graham was going to come online then.
I'm
okay.
just trying to get the camera on. There's.
Oh, okay.
There we go.
Brilliant, great. Are you able to help? Because we also have another question for PIN. So there's the first question around accepting amendments. I've got a second question that would come to you that's around.
Never offer for the first question, eh? Because then you get a second one.
Yeah, you get to say you should never turn the camera on. Do you want to go for the first one, and then I'll give you the follow up?
Yeah, I think my camera's just frozen, so I'll talk while I'm sorting out my camera.
Go ahead.
So yes, the person who asked that. You're right. The two need to go together. So if in the same way as the streamlined process for written reps works for things like householder appeals at the moment, where it's reassessed, as Stephen said in his introduction, on the basis of the evidence in the original application. That's the basis that we'd be looking at the appeals in in this widened approach. The challenge that we'll potentially face, and came up in a similar session I ran with a different group, is there will sometimes be the need for us to accept a change of evidence. For example, if the local plan has changed in the 6-month period between the decision and the appeal coming in, and clearly we're going to have to build a process which enables us to deal with that situation. There's things like that will happen, but in general, the approach will be no. We don't want the extra evidence. We want to reassess it on the basis of the way the council considered it in the first place.
Okay, that's really helpful and reassuring. I suppose the next question is about working more efficiently, I suppose, and electronically. Will PINs use links to documents on websites rather than having to send them multiple times, i.e. UDPs and local plans and that type of thing? So
I'd love to say yes. I'd love to say yes. It's a right pain in the neck having as much as we have, but the reality is we can't at the moment for a range of reasons. So firstly, inspectors, it's important to remember when an inspector sits, they are sitting as a tribunal, and because they're sitting as a tribunal, they're not allowed to go and get their own evidence. They have to look at the evidence which is presented to them. So they can't go and hunt around a website to look for information, because they will inevitably see things they're not meant to see, and then it would be a basis for legal challenge. So they're only allowed to see the stuff that's presented to them as evidence. So when it comes to things like links, you can't use a link because you can change what is at the end of a link. And so there needs to be a clear set of it. You can't have the allegations that, well, when I looked the other day it was this, and when somebody looked 2 weeks later it was a different set of evidence. And thirdly, the reason why they can't use websites is because every single council website is completely different. And so if you've got to go and find information, it's hugely time consuming to go and find the information with the way that we currently do local plans. That may change in the future, of course. Long term, yes, we want to get rid of all that, but the way the technology is at the moment and the way that the procedure rules work for the tribunals, we can't do that. But one day I hope it will change, not least because I've got about 3,000 copies of the London plan.
Right, well, yes, and that is a concern, but I mean it's really helpful to have that clarification. Thanks, Graham.
Yeah.
Okay, I think another one really. The next one is a little bit about PINs. So, noting current timescales for appeals determination, is there to be the same push for and monitoring of speedy determination regard to PINs appeal decisions?
I mean, turning into a general question and answer about the planning inspector rather than the consultation. But so
sorry,
I know. Well, I know, and it's all tied up. But if you go first, Graham, and then I'll ask.
Yeah, of course. So it depends what type of case you're looking at, of course. So planning hearings, planning inquiries, consistently, largely speaking, decided within 30 weeks, which is what we've been doing. In fact, planning inquiries are being decided faster than they have been for more than 10 years. So yeah, there are some areas where there are slow decisions, for example, planning written reps, and there are very good complicated reasons for that over a period of time. The reality is, if the planning inspectorate did decide all our appeals in, for example, 10 weeks, the reality is local authorities wouldn't be able to keep up with the work that we would require of you. So there is a sweet spot in the way the appeals system works. If the appeals are decided too quickly, it becomes an incentive to use the appeals service. That's not the reason why we take longer. It's for other reasons. But we do have to be realistic that if appeals are decided too quickly, then the presumption becomes actually people don't want a decision for local authority. They may well use the appeals system as a default, which is not how any of us want the planning system to work. So yes, we are monitored very closely on what we do and what we don't do already, and I'm sure that is not going to go away. That Stephen's nodding. He's one of the people that keeps an eye on what we're doing and why we're doing it. And I'm sure ministers will not lose interest in the performance that we undertake. But Stephen, you may want to add something else.
No, that's exactly what I was going to say, Graham. And we are still there as a department, their sponsoring department. So we will continue to work extremely closely with PINs on all aspects of their service delivery. And of course, PINs are very transparent in that as well. So they publish their statistics regularly. So not just for us, but for all of their customers and interested people to see how their performance is. So it's there for all to see.
Yeah, which is probably why the question was asked.
Okay, so just say,
I think that's it, Pete.
Sorry, Liz, I'll just interrupt if I may. Just because we've only got 5 minutes to go, and I also like to make sure that people can leave when we said if they finish when we say we're going to finish. So so thank you very much everybody for all those questions. Say there are a number of questions that haven't been answered. We'll endeavour to make sure they're answered after the meeting. But thank you very much everybody. It's been really informative to have your points raised. What I'm going to do now is I'm going to just launch a poll, but hopefully will come up. Is this going to come up? Yeah, it's come up. Great. Yeah, so just as we finished, just for you all run off, if you could just one question at the end about how useful you thought this session has been. That's very important for us in PAS and also for DLUC to know how useful it's going to be. If I can just make a few points at the end, just say following on from this, we're going to have a discussion with our DLUC colleagues about running some focus groups about the implementation of the new reforms when they are finally agreed following the consultation. So just to say that we will be looking to involve some local authorities in those focus groups and also the development industry as well in those focus groups. So so there is further work going to be happening, and PAS will help to do that. Also, just to give a shout out for another couple of workshops that are coming up on design codes. Obviously, I'm sure most of you on the call are development management people, and so there's going to be a couple of workshops on design codes on the 21st of May and the 4th of June, and these will be specifically about using design codes to inform pre-app discussions and determining planning applications. So that is being promoted on the PAS bulletin, which will be coming out on Thursday. Is that right, Shelley? Yeah, on Thursday. So please look out for that, and please sign up for the design code workshops if you can and are interested. So I'd just like to thank everybody, particularly our colleagues from DLUC, who we've given fired a lot of questions at, and also from Pins as well. But thank you everybody for your questions. They've been really helpful, and I'm sure from DLUC's point of view they're very useful to know what the feelings are from local authorities. But please, just as a last reminder, do fill out the formal consultation questionnaire and respond to that by the 1st of May. So thank you very much everybody, and I'll give you back the end of your afternoon. Thank you very much.
Thank you.
Thanks.